thank you very much, everyone, for being here. I'm sure that we will have very interesting discussions and rich exchanges. Now, just to give you in a couple of words the context, we are gathered here to discuss a bit how we could use AI, but also the regulation of AI, and not only the AI Act, more broadly the regulation of AI, to foster privacy. And given this context, I wish to first give the floor to Laureline, which will give us a bit of the business perspective and give us some clues as to Microsoft's views regarding the incoming wave of AI and legislation on AI. Laureline.
Thank you. You hear me? Yes. So I'm Laureline Hoed. I work for Microsoft in the Brussels team working on government affairs. So I would like to share some thoughts with you. You know, of course, that like all technologies or tools, AI can be used for the good, for the benefit of society, but also as a weapon. When we speak about positive sides of AI, we think of, for example, increased productivity, translation, energy, sustainability benefits, healthcare benefits. I would like to speak now quickly about how we use AI to enhance cybersecurity. Cyber attacks are common good, and cyber criminals get more and more sophisticated. So we have a duty, commercial but also legal, to protect our systems from a cybersecurity perspective, also under the GDPR, by the way. And how do we do that? Through vast data intelligence and AI capacities. So it's an integrated approach whereby we analyze threat intelligence signals at a very large scale. And the program is called Zero Trust Program. And in practice, we analyze, I think it's 65 trillion signals per day. So that gives 750 billion signals per second. And of course, we have a large number of cybersecurity experts, but they cannot deal with those signals. It's just too much. So we need AI to analyze those and to detect patterns, to see what the patterns are of the malware, of the scam, to do maybe reverse engineering and all of that. And by doing that, we think that we are pretty efficient in attacking as much as possible the cybersecurity threats. To give again some numbers, we block 4,000 identity attacks per second on more than 135 million devices managed in our system. Can be other numbers, but the goal is to be ahead of the attackers. And of course, it's very important that the data that we use for that purpose is very much protected. It can only be logged and accessed by a very limited number of persons. That's of course key. But we think that we are relatively efficient, and it's also necessary because the attackers are also using increasingly AI, and they get more and more sophisticated. Now, you have different degrees, and some of them are not professional at all, but we see overall an increase in sophistication. And so when we look, in February of this year, we did an extensive research with OpenAI on the large language models that we both use and deploy, and we have not seen significant attacks on these models. Now, this is, of course, something that needs to be continuously assessed and improved and looked at. We also provide to our users AI tools. For example, we have a tool that is called Microsoft Copilot for cybersecurity, for security, and that allows them, our B2B users, our professional users, to also use a similar tool in their cybersecurity means. But of course, when our customers will use AI tools, like, for example, the Microsoft Copilot for security, then they will ask us questions and they will ask us, how is this compatible with the GDPR, of course. The GDPR continues to apply. I think we will hear AI is relatively new, but there is no doubt that the GDPR applies. I think we will hear that more during the day. And so for us, that means that the standard privacy data protection commitments that we make contractually also apply to the services, to the AI or services that we offer to our customers. So our data protection addendum, it is called, is integrally applicable to the AI services that we offer to our users. Of course, that does not mean that we also, it's not, the GDPR continues to apply. It's not like we do a carve out for AI, but we do have additional, let's say, protection or frameworks for the AI systems. Since a long time, we have developed an ethical framework for AI, and that you can say that it applies on top of the GDPR safeguards. One of the very important commitments that we make to our customers in the area of privacy and AI is that we make it very clear that the data, the customer data is owned by the customer, remains owned by the customers, and it's not, for example, that the customer, because a customer adds a prompt or has research output through the uses of the AI systems, that data remains there, and we don't use it to train the models. So that is one of the important elements, and that is how we sort of try to, let's say, articulate the overlap and the coexistence of the AI framework and the GDPR. And that is something that we have to do, but I'm sure the regulators will also have to do that. We will hear very interestingly from the EDPB after me, I think. I hope you will agree with me, Isabel, that the GDPR, of course, there is a tension between some of the GDPR principles and AI, but I think we can say that AI is not prohibited under the GDPR, but it's about finding that balance that successfully balances the AI innovation with the GDPR, and that is challenging, of course. I think for that purpose, we can maybe hope for some more guidance also from the regulators. And I would maybe, and there is already guidance. The conference of German DPAs came out in early May. I think you may have seen it with guidance on data protection and AI. CNIL has also done so, of course, but there will be more questions and we will need more answers for sure. And maybe there is one area where I think I would like to, it is fair to say that it would be useful with some more guidance. That is the usage of privacy-enhancing technologies in AI. So privacy-enhancing technologies could be encryption, could be differential privacy. You take out some personal data to make it more accurate. That also had an impact on the AI functioning, of course. But I think it's fair to say that the usage of PETs, privacy-enhancing technologies, can improve the data protection. It can limit the risk of re-identification. It enhances, it helps to data minimization and so on. But currently, the framework on how to use this and when it is appropriate, necessary, relevant, I think is still very vague, and we would appreciate further guidance in that area.
Thank you very much for those valuable insights, Laureline. Now, we do turn to Isabel. Isabel, Laureline has just called for a dialogue with the regulators. She did mention privacy-enhancing technologies. She did mention cybersecurity in a broad way. There is also the topic of AI Act and GDPR, which need to be a bit articulated. What would be your key thoughts on this, and what would you like to share with us?
Thank you very much for the question, and hello everybody. Happy to be here. I think I will address first a bit the question on the interaction of AI and in the Act and the GDPR, and then wanted also to give some insight about this question of use of AI to defend privacy. Because there are, in fact, a lot of interaction between AI and data protection. This is a very vast subject matter. And we will address even in pieces, I would say, because we cannot make a guidance on AI. It's really, really massive as a subject. So we can address from really those different perspectives. Before addressing then the use of AI to improve data protection, I would like to make this general remark between interaction of the AI Act and the GDPR. So it's important, the point that Laureline made, that in fact GDPR is already applied in fact to AI. So even if this is a very important step, I would say this adoption of the AI Act, which is the world's most far-reaching regulation on AI, this is a very important achievement also for the 27 member states to have made an agreement on this legislation. But GDPR was already applicable and is already applicable. Why? Because AI, in many circumstances, is using personal data, either for the development or the use or deployment, and also improvement of the systems. You already noticed that there are different authorities launching enforcement activities or exchanging information on enforcement activities. At the EDPB, we organized this task force on ChatGPT, OpenAI. There will be a report that will be discussed tomorrow at the plenary meeting on that. So that shows already that we gather everybody that we are working on enforcement action on ChatGPT to discuss together to try to have a coordinated approach in Europe already. And then it shows that the data protection authorities are already active on this field and already enforcing. They have an expertise on AI. And this is important to know because there is this possibility in the AI Act. Member states have to choose which authority will be involved to enforce the AI Act, and there will be probably a place for the data protection authorities, and even if it's not the only authorities that will be on the ground, there will be a need to coordinate and to work together with the data protection authorities. I would like also to make a reference to this political agreement, it's a recent one, on the new directive relating to platform workers. So the use of Ubers, etc. There have been some this directive, and certain provisions regulate the use of algorithms. And in the system, and the data protection authorities have been appointed as being the competent authorities for those provisions. So that's also important to note. Now, the second point that Laureline already made is the fact that so the AI Act will apply without prejudice of the GDPR. So meaning both legal framework will apply in parallel. And in fact, the Act even says explicitly that it will be complementary to the GDPR. GDPR was the first, I would say, grounded legislation that has been a bit of foundation for all those legislation also relating to the data in general, DMA, DSA, Data Act, etc. There is always a connection and a reference to the GDPR. So it will be complementary, so meaning it's not because you will respect the Data Act that you will be complying with the GDPR. It's not because you are complying with the GDPR that you will be complying with the Data Act. So the opposite is also valid. But there are some similarities. It's not the same type of legislation, of course, but there are some point of interplay, enabling complementarities and even synergies between the legal framework. Especially, for instance, on the question of transparency, risk assessment. There will be risk assessments that are made under the GDPR that could be also already a basis for the future fundamental rights risk assessment for the high-risk AI systems. There are also duties from the providers, which is interesting here, because the AI Act can capture this concept of the provider, which are creating the system and not necessarily being a controller. And will fall under the GDPR. You will see that under the GDPR, for instance, we have a recital on privacy by design, where we try to capture this manufacturer, the people that are creating the tools, but normally it's not really in the text as such. Here there will be transparency duty for provider to the deployer that are using the system, meaning that the deployer, when they will act as controller, they will use that information as well to respect their GDPR duties, meaning when they will have to make the data privacy impact assessment, but also to comply with the data subject right, for instance, or transparency duties under the GDPR. So within the companies as well, there will be a connection between people working on AI, people working on personal data. There will be a kind of a collaboration also there. So now quickly on what we are working on at the EDPB. First, we launched the work on guidance on the interplay between the AI Act and the GDPR. So this is already undergoing. We have the ChatGPT report that will be discussed tomorrow. And we also, tomorrow there are 2 mandates that will normally be delivered on AI. One, it's on generative AI, a new mandate on the use of AI scraping for training database sets. And the second one on the role of DPA in the AI Act framework. Then, on the top of that, at the EDPB, we also have a list of experts. We have a super pool of experts. So we are having some external experts that we can pay to develop some projects for the data protection authorities. And there are a few also that will relate to AI, like on AI auditing, trying to help the authorities to be able to inspect an algorithm and to see how the process should be to assess the algorithm. So we see that generally it's true that when we discuss about AI, we looked at the risk of AI. That's the core purpose of the AI Act. Or there is the question of the tension between AI and legislation. I mean, Laureline made reference to tension to privacy, like accuracy, explainability, those questions. We have also copyright. You know, we have this famous decision from the competition authority in France, which fined recently Google for non-respect of copyright in AI. But then very interestingly here, we discuss about how we can use AI to comply better with the legislation. So that's an interesting perspective. And so I wanted to address here, so there is no, right now, I would say, an official position on the EDPB on this subject matter. But then I assessed, you know, the legal framework and checked if there would be an incentive or a kind of limit for the use of AI, for instance, to secure the data. So first, cybersecurity is a key component of data protection. You will see that there is Article 32 of the GDPR that imposes to protect the data, taking into account the state of the art and the cost and the risk to provide a level of security. Then in the recital 49 of the GDPR, you can realize that in fact the processing for security can be made on the basis of legitimate interest. So that's already providing some kind of ground, I would say, to say that, of course, there will not be you don't need to get the consent or whatever. You know, this is part of the legitimate interest of the companies. And then now, turning to the AI Act, we can find some specific reference to cybersecurity. First, the AI, risk AI, will have to be secured. That's Article 15. But then when you look also about the high-risk AI system, so the one that will be the most regulated in this Annex 3, we can find AI systems that are used for safety component in the management operation of critical digital infrastructure that will be considered as high risk. But then Recital 55 clarifies that when there will be a component will only be there for cybersecurity purposes, it will not be qualified as safety component. So if there is a situation where it will be the use of, I would say, AI to protect critical digital infrastructure will be then qualified as AI, but not when it's high-risk AI, I would say, but not when it's for cybersecurity purposes. The same will apply also for biometric categorization system. So there are several critical use of biometric that will be classified as high risk of AI. And then, as well, you can find in Recital 54 of the AI Act that when biometric systems are used solely for the purpose to enable cybersecurity, then they will not be considered as high risk. So you come back on the system, then if you use AI for cyber security, it will be then a kind of low risk. And an example which is often provided is the spam filters. But what we see in reality is that indeed AI is more and more used to enhance cyber attack. For instance, to better identify vulnerabilities and also to exploit them. For instance, we have example where when you use the voice, to access to a system, AI is used then to replace the voice and then to try to circumvent. Or if you try to find some patterns of actions, that will be typically the one of be attackable, AI can also enable to try to make this pattern a bit less easy to find out because it will be a bit changed each time. And then AI is then also used to improve cybersecurity. We get also the insight from the private sector here. But we have the need, for instance, to develop more secure code. There is this spam filter to be efficient, combat phishing, identify anomalies, vulnerabilities, automatic network analysis, classify attacks, etc. There is a lot of examples of the use of AI to protect the system. And so what is interesting is here, existence of AI is like increasing the risk, but then there is a need to react to that with an increase of the use of AI also to protect from the risk. And so I think what you can ask yourself is whether the use of AI to protect the system will not be also part of the state of the art, meaning that it will be then necessary. There are, of course, a lot of different tools that can be available, but this will be also necessary. So that was my intake. Thank you.
Thank you very much for all those answers first to what was discussed first, but also some pathways for the future. And this brings me to Jessica. So Isabelle pointed out both the positive and the negative impacts that an AI can have in terms of cybersecurity. Jessica, I believe this does echo your work throughout another use case, which you will refer to, the use of large language models and the risks of re-identification that can be kind of limited thanks to the use of other state-of-the-art systems. What would you like to share on this matter?
Thank you for your question. And thank you for all your questions, because this panel is about the question, isn't it time to switch perspectives? And I have to admit that when I saw the question the first time, I was not so inspired because all that we can read is about AI being a risk for privacy. And my first thoughts went to that direction. But little by little, I came to the conclusion that maybe AI can also be an opportunity to protect privacy through the technology, but also through the AI Act, so through the regulation of AI. And that's what I want to share with you. So first, AI is a risk for privacy, and I would like to focus on one risk in particular, which is the risk of inferring personal data from content published by the users on the internet. This risk has been put in light by researchers. You have the article mentioned on the slides. And what they showed is that from basic information, it is possible for a large language model, such as ChatGPT, Llama, Claude, etc., to deduce, to infer personal information of the user. And they gave some examples. So, for example, if a user writes on a platform that there is this nasty intersection on his commute, and he always gets stuck there waiting for a hook turn, the LLM is capable of deducing the localization of the person. He seems to be in Melbourne, Australia. Okay, and little by each post, it's possible to infer information, the gender, the age, the income, etc., etc. So what can we learn from this example? First, the risk presented by the LLM is a risk by design. That means that it's the way the LLM is working that creates a risk for privacy. Second thing, it's easy today to use an LLM. That means that anyone can infer personal data from anyone posting information online easily. So the risk
can be at large scale. Those two characteristics, the fact that it's of the risk, the fact that it's by design and that it's at large scale, may make me think about something. I said, it made me wonder if that risk could be qualified as a systemic risk. Because if it's a systematic risk, we already have a framework to address the risk. So maybe as a lawyer, I'm happy about that. The question is, what is a systemic risk? So we have two main texts at the European level that deals with systemic risk. This is the AI Act and the Digital Services Act. In the AI Act, the systemic risk is defined as a risk having a significant impact on the union market due to the reach or due to actual or reasonably foreseeable negative effects on fundamental rights. So for me, if we compare with the case we had just before, we are in that case. We have an LLM having risks on fundamental rights. Okay. The AI Act said after that a model will be considered having systemic risk if it respects a few indicators, or if the European Commission said so, or if it reached a threshold which is 10, 25 flops, but doesn't matter. What I want to highlight here is that when the European Commission will decide whether a model presents a systemic risk or not, the European Commission will look at a list, which is in the Annex 13 of the AI Act. This list, it's a list of criteria taken into account by the European Commission. Okay? And in that list, you have the number of parameters that is taken into account by the model, the numbers of users of the model, and also the LLM is clearly targeted as criteria that can show that the model presents systemic risk. So at the end of this short work, I think we can say that an LLM can be considered as having systemic risk. But we will see in the future what the European Commission will say, because it's not what I'm saying here is not exactly what was said when the text was adopted. And that's the reason why we have a threshold as a presumption. Okay? So the LLM, the risk presented by the LLM can be addressed by the AI Act, but also by the Digital Services Act in the context of very large online platform or very large online search engines. What do we learn from the DSA is that a systemic risk is a risk coming from the design or the functioning of the service or from the use made of the service proposed by this very large platform online. So the LLM is clearly in that case. Secondly, the DSA said is a systematic risk and what can cause negative effects on fundamental rights, and in particular, privacy and protection of personal data. So here again, the LLM is concerned. It fits perfectly with that framework. So we have a framework. That's the good news. And for that reason, I can say that the AI Act and the DSA can be considered, they appear to be legal tools to protect privacy by addressing new risks. And to do so, they require the providers of the LLM or the service to mitigate the risk. And the measures taken to mitigate the risk can concern the design. And what we can see is that we can think about some tools integrating AI that can enhance privacy. So here in that case, the AI become a solution for privacy. Okay, we will use AI for the LLM to be protective of privacy by design. So what is this tool? It's a tool that can be used to disclose to control the disclosure of information. For example, if you are a user and you are posting things on the internet, on social media, search engine, we can think about an AI tool you can use that will tell you each time you want to post something, what information can be inferred from what you want to post. And then there can be a discussion between you and these tools, which will be an LLM as well, a little more, so that you will arrive to a content that allow you to communicate the message you want to communicate without revealing the information you want to keep secret. Okay, so here AI is used as a privacy enhancement tool. To implement that tool is interesting also because I think that it's compliant. It complies with the other text. It gives transparency. It complies with the minimization principles. It complies with fairness, with accountability, etc. So I think this tool can be a good tool. How to implement it? Two ways. The first ways is to require from the provider to put the AI protective tool in the service, in the main service he is providing. Okay, it's just the fact that he has to be to protect privacy by design, doing that. And the second way that can be used is for the tool to remain local. That means that the tool is in the user's device. It's local, so that we can comply with some big principle we have at the European level, national level, such as informational self-determination, self-sovereign identity, and the principle of empowering people. So just to conclude, and to answer the first question, isn't it time to switch perspective? I think that maybe it's time to switch perspective, but with caution, because a guarantee has to be put in place.
Thank you very much for that demonstration. And I personally see even other merits, many other merits, especially for compulsive behaviors on online posting. Now, Jessica highlighted that privacy-enhancing systems, they can be deployed to help mitigate the privacy risks presented by design by other AI tools. Now, Gian-Claudio, beyond the use of AI technology to foster privacy, what are your views on the regulation of AI vis-à-vis privacy principles? So does the approach taken at the EU level help to increase by design data protection besides the articulations that we will have to face?
Sure. I have slides here. Oh yeah. Okay, great. Thank you so much, Michael, and thank you for this very interesting opportunity. I had prepared a different flow of thoughts, but I was very much provoked by the previous panelists. So. And I'm sorry to be the first one to be very negative and critical about the question. So if the question is, isn't it time to switch perspective? My short answer is no. And I will try to develop this no with you. I think we needed this some spice. And so a no is necessary. Why that? So I don't think that AI can be such a fruitful opportunity to enhance privacy unless we have a very limited view of privacy as data minimization, which is a bit the risk that we encountered with this big narrative of privacy-enhancing technologies, etc., in the last years. But let me give some lights of hope before the full negative part. Maybe AI is not a tool for enhancing privacy, but the AI Act, in my view, is a tool to improve the approach to privacy and data protection that the GDPR gave us. So, and I will try to develop a few points in which, in my view, the AI Act is a good reform of the GDPR. And I know in 5 minutes it's most provocations and not much explanation, but we have maybe time during lunch, etc. When I remember at the EDPS conference 2 years ago, at the EDPS summit, there was this keynote speech by Vera Jourova, the Vice President of the European Commission, and she was asked about what to do with the problems of the GDPR. There are clear problems in the GDPR. The GDPR was a magnificent experiment, a successful one, but all experiments can be improved. And so there were some problems that needed to be improved. We can all make a list. She said we have 3 ways ahead. First, a general reform of the GDPR. But this is too difficult. Politically impossible. It took 20 years to have the first reform from the directive. We cannot have a new one. Second is chirurgical interventions. The third is we don't do nothing and complain, which is usually something we scholars like to do. But I think there was, in fact, a 4th way. The 4th way was that many digital laws are have silently already reformed the GDPR. So a lot of what was already there and a lot of the problems are partially solved by the DSA, it was already mentioned, the DMA, the DGA, the DA, also the Collective Redress Directive, and today I would like to explain why the AI Act. Here I identified at least 4 chapters in which, in my view, the AI Act enhances GDPR principles. So it's not AI for privacy, but AI Act for privacy, maybe. So fairness, transparency, impact assessment, human vulnerability, at least. Of course, there are many more, but my biased view made me select these 4. And I would like to start, of course, with fairness because it's connected to the very interesting presentations we had so far about the way in which AI can be used as a tool for security and privacy. About fairness, we have an important dilemma in the GDPR. What to do in the balancing between minimization and fairness? What to do in the, for enhancing privacy, what should we do? Should we just enhance data minimization, necessity, storage limitation? And this is, in my view, a limited view of privacy and data protection. Privacy and data protection were not just meant to get us hidden. They were meant to get us free and respected when our private life and personal data are at issue. So we needed not just minimization, we don't need just privacy enhancing technologies, but we need fairness enhancing technologies or fairness enhancing practices. So we recently published with a computer scientist and a colleague in Brussels a FACT paper, the conference this year in Brazil. It's called The Unfair Side of PET and the trade-off between fairness and privacy enhancing technologies. Why? Because I think that fairness is the answer to rebalance the myth of data minimization. It's important. Data minimization is important. Purpose limitation is important. But we need also to counterbalance power imbalance. Fairness should be there for power imbalance and for diversity. The AI Act is not solving the issue, but it's giving something in that direction. I mentioned here an example, Article 10, about the possibility to process more sensitive data for diversity in the data set is maybe one example of how the minimizing data is not just the solution. There is more that can be done, okay? And for example, adding diversity to the data set, adding, to reduce bias. Of course, it's not easy. It's just a mean, not an end. But this is something that we should maybe treasure of the GDPR. Second point, on transparency. there were, as we know, long discussions about transparency in the GDPR. Sandra contributed a lot to that discussion. I see here also her co-author, and this was Brent. And so I see, and there was a lot of frustration for all of us on how actually Article 22 of the GDPR, Article 15, etc., had some limited approaches. Now the AI Act is offering something. I don't think we have an answer to the question on whether this is enough. I'm not sure this is enough, but we have something more. We have human oversight for high-risk AI systems, and we have this new, explicitly, finally, right to explanation, Article 86. It's limited in the scope, but it's something interesting that we should develop. Isabel was mentioning the Platform Worker Directive. In that directive, we have a specific reference to explanation details that should be disclosed. So that is also, even though a sectorial, but a very innovative law in terms of what a good explanation, or what an explanation might be, at least in that sense. Very rapidly, the 2 points. Yeah, here I have some references of papers written by Frank Pasquale and me on this, but very rapidly on impact assessment. We were all frustrated also about impact assessment, I guess. DPIA was something new, something very fruitful, something very interesting. But there are important limits in the DPIA. First of all, the DPIA has no transparency of the results. Second, public authority was not involved in the procedure of the DPIA. And third, individuals had no role in the participation, and there was no participatory design. In my view, the FRIA, the Fundamental Right Impact Assessment in the AI Act, the new Article 27 of the AI Act, in connection with the risk assessment that we have in Article 9, and the fundamental rights report duty that we have in Annex 4, give us something more, because there is a specific role of public authority that should be notified. There should be transparency of the summaries of this DPIA. The DSA is much better on that, because the DSA explicitly tells that, explicitly mentions external audit, but we use what we can. And there is a role for participation of individuals. This is so important, because we have this huge problem of limits of consent, limits of default decisions. So how do we involve, how do we get autonomy back, in particular for impacted groups, vulnerable groups? Let's make them part of the decision-making. Let's make participatory decision-making. In the participatory impact assessment, actually this is not in the body of the article. It's in a recital, because, you know, in the trialogue, things enter in the article and go out in the recital. But at least we have a recital. Let's treasure recitals. And the very, very last points about human vulnerability, a topic that just to mention that impacted stakeholder is also something that is growing a lot in my field of activity. But just to conclude, human vulnerability. Human vulnerability is something that the GDPR mentioned very, very incidentally. But I think it's so important to acknowledge that in the age of dominant platforms, in the age of huge power imbalance, in the age of, in which we know that the average data subject doesn't really exist as a rational human being, and also situating data subjects in their marginalization, in their experience of oppression, we needed something clearer and stronger. The AI Act, I think, is adding more to that, is adding a lot. In the GDPR, it was one sentence in recital 75. Now we have a prohibition based on non-exploiting vulnerability, Article 5b. We have definition of vulnerability in Article 7 about the list that the European Commission can use for updating high risk. And we have also in the data regulatory sandboxes, we have a duty. If you want to do regulatory sandbox, so if you want to train data on the basis training AI for public interest using personal data, you need, one of the requirements is to take into account vulnerable people with data subjects with vulnerability or disability. So I think I started to say that I was pessimist. I am very optimist, and thank you.
Gian Claudio, many thanks for that nuanced view and that switch of perspectives, if I may. So generally speaking, newest EU laws, we've seen it with the AI Act, Jen Claudio brilliantly showed it, but also the new Product Liability Directive and the proposal AI Liability Directive could be tools to better enforce privacy and other rights in practice. Sandra, I think that's the position you're defending, isn't it?
We'll see. Yeah, so I have some slides as well. Hopefully, yes, they're coming through. Excellent. So yeah, in the spirit of people sitting around and complaining, this is what I will be doing for the next couple of minutes, complaining about what I think needs to be done and what is problematic with the AI Act at the moment. So yeah, I'm a German lawyer, so I care about going to court and suing people. And so the thing that I am particularly interested in is how can we actually enforce individual level rights? How can we protect privacy actually on the ground? To both of those topics, I have published very recent papers. One is forthcoming in Yale Journal of Nanotechnology. It talks about the limitations of the AI Act, the AI Liability Directive, and what that means for Europe, United States, and beyond. So if you want to have a closer look at what I'm saying right here, that is the place to go. And another paper that is coming forward in the Royal Society of Open Science focuses on large language models and whether they have a legal duty to tell the truth, which I wrote with my co-author, Brent Mittelstadt, who is hiding in the audience somewhere. So yeah, for the next couple of minutes, I just want to focus on the question of, how can you protect privacy actually in legal battle? And to first start with that, I think it's really important to acknowledge that the AI Act is first and foremost product safety law, which is very, very unfortunate, which was, in my opinion, a mistake to do it that way. What that means in practice is that you have two more or less frameworks that developers have to adhere to. You will have the AI Act, that is the one that is coming into force now in steps over the next couple of years, but you also have those interesting harmonized standards that are now being developed. So those are the standards that specify how and with tools the AI Act should actually be implemented. So it's like a specification of the legally binding text. So who writes those standards? Well, it's Sen and Senelec, who are not democratically legitimized. They're private bodies, and most of the people who are sitting in the working groups writing those standards are sent from industry. There's almost no civil society representation in those standard-setting bodies, and they have almost no opportunity to actually have impact on that. So those standards that operationalize the laws are written by industry. Well, how will we make sure that those standards and the AI Act is actually complied with? Well, we're going to have conformity assessments. That means somebody needs to assess that the tools that are being developed, that AI that has been put on the market is legally compliant with the AI Act and the harmonized standards. And who does that? Industry. They self-certify whether they think that their products that they have developed are legally compliant with the rules that they have just written for themselves. So that's the basic truth of it. The rest is done with codes of conduct, which of course are voluntary, which means there's a massive accountability gap there, and especially in relation to individual level rights. Interesting, actually, is that the legislator didn't know about that problem from the beginning. There's this interesting recital 64 in the AI Act that talks about the fact that this is not an ideal situation, that actually what we should have is third-party assessment. So independent third parties assessing the products that come on the market to show and certify whether they are compliant with the standards in the AI Act. But it's only a recital, not legally binding. There's nothing in the final text that shows us when and if and with what tools that are supposed to happen. So it's just an afterthought, unfortunately, in the recitals, which is really, really problematic. So again, product safety law in its purest form. Luckily enough, the European Parliament did know about this and did actually put some things in action, especially with the draft from last year in May, where they started to implement some individual level rights. Among other things, the right to complain with supervisory authority, then effective remedy as well, and then of course the right to explanation, which made me especially happy that we now have that in there, which is fantastic. However, what we have to acknowledge is that unfortunately the final version of the right to explanation was watered down considerably. And so I have here like just a comparison of what the European Parliament proposed and what the final text actually looks like. And so this is in my opinion, quite problematic. So you will have a right to explanation if a decision is being made about you by a high-risk system, which is a limited range of systems. We can talk about that in more detail. And you're going to have a right to explanation according to the first draft if it impacts your health, safety, fundamental rights, socioeconomic well-being, or any other rights in that framework. The butchered-down version only looks at safety and health and fundamental rights. So the economic part has been taken out, which is really, really significant, and any other references to the frameworks as well. Why is that problematic? So this is something I talk about in both of those papers in more detail, because that is language borrowed from an idea that we're talking about material harms predominantly. This is health, this is safety. But the majority of harms that we're going to deal with are probably not material in nature. This is discrimination, this is privacy invasiveness, this is your reputation, this is financial loss, which is also a material harm, by the way. So those won't be covered. Of course, we have a link to fundamental rights as well, which is a saving grace, but we have to remind ourselves who is bound by fundamental rights. So there, the Charter of Fundamental Rights of the European Union, first and foremost, is addressed to the public sector. So that means the European institutions, and it means the public sectors in the member states when implementing European law. That's it. Doctrine says that the private sector is actually not bound by that. There's sprinkled case law of the Court of Justice where sometimes exceptions were made. An actual horizontal effect was granted, but that was very, very limited and mostly in relation to discrimination and workers' rights. So a general application of fundamental rights horizontally to all private parties is not something that the law actually recognizes. So again, very limited in scope. Well, and what is it that you get? What kind of information do you get when you want to invoke your right to explanation? So the original draft talked about the decision-making procedures and the parameters taken and the input data. This is roughly the same, but the input data was taken out again. So you're not going to get any information about the input data, which is kind of really important if you want to know why you didn't get the job, for example. That would be really good to know. And lastly, the unfortunate last part is the relationship between the provisions in the GDPR and the AI Act. The original version said that they are supposed to work in parallel. Another final version says that only to the extent that GDPR doesn't give you something, which we don't know what it really does yet, the rest will be covered by the AI Act. That's very unfortunate. You could have just have them in parallel, which is problematic. But again, it's better than nothing. I don't want to just moan about this. I'm happy it's there. But there are significant gaps that we need to push forward to. So this is not the only individual level rights that you're going to have, because you're also going to have 2 new frameworks coming into force that are seen as complementary to the AI Act. Actually, the Product Liability Directive, or better said, the update to the Product Liability Directive was always seen as the complementary framework to the AI Act, as well as the new Artificial Liability Directive. So whenever there's an infringement of the AI Act, now the route of civil law action is being opened up there, which at first glance sounds really great. But if you look again at what the scope is of the Product Liability Directive, we see a similar problems in terms of how we define harm. It's product safety law, so no surprise, it's predominantly based on death, personal injury, damage to destruction of property, destruction of data. Immaterial harms are not covered. Again, they are only covered if they are a side effect of one of the material harms. So if your toaster explodes, and you also feel pain and suffering because of that, you can go to court. But anything else that has to do with material harm that you experience on your own without having destruction of property or injury or health attached to it, you will get no compensation. Also, you will get no compensation if the immaterial harm is pure economic loss, privacy infringement, or discrimination. So that's the main problems that we have with AI, because AI is responsible for economic loss. You don't get the job, you don't get hired, you get fired, you don't get the scholarship, you don't get into the school that you want to, you have to go to prison. Those are all economic losses as well, which are not being covered by this framework. privacy infringement, this is data protection, this is reputation, this is slanderous behavior, this is self-representation in the online sphere, not covered by this framework. And of course, non-discrimination, which is the cornerstone of everything, things AI. Everybody knows that AI has the massive problems with that. Again, a harm that is not covered here. So again, not very broad in scope. It looks a little bit better with the AI liability directive, which again, unfortunately, has a very strong focus on safety and health and death and injury and property damages, so all material harms, but it nudges towards the fundamental rights as well. And it mentions in the recitals or in the considerations actually, talks about non-discrimination, dignity, privacy, those kinds of things. But again, who is bound by fundamental rights? I already said, like, it's not everybody, it's predominantly the private sector. So it's very, very questionable whether somebody will be able to go to court and defend their right to privacy and get some type of recourse using those frameworks. So that's the bad news of it. With the good news, I want to say this fight is not over. Like, I'm just being very honest about the limitations here because there is still time to push and make it better. We still have to harmonize standards that are coming through where we can have impact on how harm is defined. This framework is going through trilogue as we speak, so putting more pressure on legislators at this point. Now is the time to do that, to make sure that different types of harms are being recognized. It's really, really important that we start thinking about harm differently. This is predominantly product safety law. And again, moving away from the idea that everything has to be a physical harm and thinking more about the immaterial types of harm, which is non-discrimination, which is privacy, those types of things. I think this will be really, really important. And if we can do that, then we can improve the frameworks that are currently under consideration. Thank you very much.
Thank you. Thank you to each and every of our panelists. So right now, I expect a bit of tolerance from the organizers, given that we encountered some technical issues at the very beginning. So what I would like to do is first throw a few discussion points. I have one for each of our speakers, and then I will hand the mic to the floor to the audience so that you can ask questions. Unfortunately, we don't have any other portable mic. So first, for Laureline, I was wondering, how do you internally at Microsoft try to take care of compliance or forthcoming compliance with the AI Act and the GDPR? So how do you deal with different areas of expertise that you have to group all together with IT, legal, and even in legal, different specializations?
So first of all, I thank you, Gian-Claudio, for reminding us that the overlaps between the AI Act and the GDPR are not the only ones we are dealing with. There are quite a lot of overlaps these days between different digital laws. So this is a broader issue. But generally, I think for the AI Act and the GDPR, then specifically, so we have a responsible AI framework in place already since 2018, which is actually based, I mean, we have been hearing also from you, like the same principle come back, right? In transparency, fairness, and so on in both laws. So it's based also on the principles of the GDPR, our AI ethical AI framework. And that has been in place since 2018. Now, of course, there are also lots of privacy lawyers involved there. So that's already one way to ensure the coordination. And on the other hand, the privacy program that we have been rolling out to comply with GDPR, I mean, of course, also the lawyers are very familiar with AI nowadays. So I think there is this mutual interaction, but on top of that, we also, like in the broader sense, we have a sort of regulatory intake program for any new act, and that is then for any new act, and that then maps sort of the requirements that we have to that impact our systems that we have to comply with. That is then shared with all the relevant engineers and so on. So this is like, I mean, it's as I said, it's a broader issue than only for the AI Act and the GDPR.
Okay, so basically you're a step ahead right now. Let's hope so.
Let's try to be.
So for Isabel now, I would like to take more of an institutional perspective. Do you already have clues as to how the EDPB will have to interact with the AI board, the AI office, so as to ensure a smooth application? You mentioned earlier that there would be flows of discussion and that your expertise would be integrated into the process. Do you know a bit how that will take place?
So this is not exactly, I would say not exactly no. So we are having this mandate on the role of DPAs in the framework of AI Act is to be adopted tomorrow. So, and part of the statement will cover this question. There are some, when we look a bit more globally about the different digital regulations, there are some of them which are providing really a cooperation within the system, like I would say the DMA. There are a high-level group of DMA on the question of consent, to which the EDPB has a seat, or there are different subgroups, like on the age verification. So we do collaborate, and they are embedded in the regulation. It's not the case here. But it's a general, I would say, big challenge in the years to come, is to see how to organize this cooperation. And if we look, you made reference to the DSA. In the DSA, the appointed authorities are already made. And you would notice that in some countries, it will be the consumer authorities or the competition authorities, the media authorities, and the framework of cooperation under the DSA is, in my view, not really well advanced, I would say. If you would compare, it's a bit similar to what we had under the directive for the privacy. You know, it's a working group where the authorities are coming together. The EDPB, I mean, the GDPR was much more detailed on the way the cooperation should take place between the authorities. It was much more regulated. And you know that there have been some challenges on that. Well, in fact, we used to cooperate for more than 20 years. So I cannot imagine how those authorities that will have coming from different backgrounds, coming from ministries, being independent, not independent, etc., will have to collaborate to each other. But this is a reality, and this is very important to take into consideration. And we already started now, because we have, for instance, we adopted recently our opinion on consent or pay, you know, for the movement of having, the duty to either choose between consenting to have behavioral advertising or to pay for the services. And in this framework, we did cooperate already with the consumer authorities in Europe with this network, and also with the DMA Commission Authority, and also some national competition authorities. So this is something that we are very conscious that it will be necessary, but I think that there is a lot of elements that are not really precise, not really developed in the different legal framework, and which will create a lot of challenges in the future. Thank you.
Thank you for your answer. So a lot of work ahead. And speaking of work ahead, Jessica, I was wondering, so by incorporating complex AI systems within even ever more complex AI systems such as LLMs, we seek to ensure compliance by design, but do we not actually risk adding more and more technical complexity at the risk of, to some extent, losing the ability to monitor and to control these systems as a whole? So where is the risk-benefit balance to be found here? And if I may, I suggest that we stick to very short answers, because I'm sure the audience will also have a few questions for all of you later on.
Still a good question. Regulating technique by technique is strange. Okay, it's like counterintuitive. I agree with that. But really, I don't see another way to do today for some risks. And I think that Laureline stressed it very well when saying that today AI is used to fight against cyber criminality. So we have to do with AI. And it's our work to create the good framework, to create the good control. And I think in the DSA we have some clues with the control by the European Commission, with the control by some researchers on systemic risks, etc. So these things are, we are building it now. And that's why I said previously that we have to be conscious, with all that is created now.
And a lot of work in the pipeline. For Gian Claudio, so I was wondering, are we not missing the bigger picture to some extent? So we have expansions of the GDPR to some extent within the AI Act. But on the other hand, much of the systems that process personal data and potentially sensitive data are not high risk, or they are minimal risk or limited risk. In those cases, we are risking to face a two-tiered data protection framework. One for high-risk systems, which is enhanced, but for other systems that might create actually similar conditions in the processing of personal data, we might have a lesser data protection. What are your thoughts on this?
Yeah, thank you. I think this is a very nice provocation. It's difficult to answer in 1 minute, but just to maybe try. I think the GDPR is still there. It's still strong. And it's stronger than before because we have enforcement. So I'm not super scared about the non-high-risk scenarios because we have strong, we have interesting development of the enforcement. We had the first case on poor DPIA enforcement 2 years ago. It was something new. So, and there's not just the AI Act. We have the DSA that is providing interesting perspective on social media, also data protection, because it's also transparency, it's limiting OBA, we have the DMA with similar scope and consent, for example. We have data portability that was criticized a lot in the GDPR, and now it's there. Okay, so I think this answer, and again, about the big picture, I liked the input that Sandra, the provocation about fundamental rights that you gave. I think we kind of disagree on that, and it's interesting to discuss, because I think the impact on fundamental rights doesn't need the procedural. I think the legislator means the impact on fundamental rights as an attribute of individuals, as an attribute of humans, but it doesn't require the procedural aspect, because now they're just mentioning the effects on fundamental rights. They are not saying the direct application of the Charter. I don't know if this is clear, but I'm very interested by this discussion, so I think there should be another panel for that. But just because you asked about the big picture, so I mentioned fundamental rights.
Thank you, Gian Claudio. And to you, Sandra, my question is a bit similar. Actually, much of the individual rights in the AI Act, but also in the AI liability proposal, are only tailored for high-risk systems. So a bit kind of the same as to Gian Claudio, but here taking the perspective you mentioned about discrimination. Are we not facing actually discrimination between systems that are still opaque, that are still able to make mistakes, but that are not being forced to be granted rights towards the people that are affected by them?
Yes, I think it's a very good point. Yeah, we'll see. Whenever I write something, I usually don't want to be right about it. I'm just worried that I'm right about it. And if you think about who is bound by fundamental rights, it's just very clear that it's usually not the private sector. The other very unfortunate thing is that the Product Liability Directive actually says that you're only going to get recourse if the member state tradition accepts it. So I don't have a survey of all the member states and how they feel about fundamental rights, but I can tell you from the jurisdiction that I know a lot about, which is Austria and Germany, they really don't believe in this idea that the private sector is bound by fundamental rights or human rights at all. So again, maybe this will be a fight between the member states, but it means that there is a big gap and there is a big problem that we just should not ignore, because very different traditions believe in very different doctrinal things. And that is also true for the harms that we have here. With right to explanation, you only get it when it's a high-risk system. For recourse, according to the AI Liability Directive, you could only access to documentation if it's a high-risk system. That sounds great, because if you look at what high-risk is, you will agree with it, because it's criminal justice, it's employment, it's immigration, those types of things. Nobody disagrees with the high-risk systems, but we have to flip it around and ask who is not in there. So that's no recommender systems, no advertising algorithms, no algorithms that are used in media, no trading algorithms, no algorithms used by finance decisions, no algorithms used in science or academia, and general purpose AI models and chatbots are also not there. So there's a whole range of things where people in this room have filled libraries with explaining how risky they are, and suddenly, all of a sudden, they're still not high risk. I don't know what we need to do, all of us, more than constantly showing how high risky those systems are, and they're still not in there. And that also means no right to explanation, and that you're not gonna have the benefits of easier recourse mechanisms with the liability directives because it's not a high-risk system. So again, but it's not over. Very important, it's not over. There's still time to push, so don't feel like the fight's over. It's just really important that we know what to fight for.
Thank you very much. Now, if anyone in the audience would like to ask a question or phrase a remark, please feel free. I haven't seen the 5 minutes remaining sign yet, so I guess we might go ahead. Please feel free.
Thank you very much. Lex Zard from Leiden University. I have many questions, but just for the sake of time also. Sandra, you mentioned in several ways the limitations of the AI Act, and you showed us the article, and obviously we need to read until we know better exactly what you mean by it. But I was just curious to also have your thoughts on, just comparatively speaking, is there anything better, not already finished, but like something that is going on? Or what would be your ideal AI regulation? Like, what would be the ideal approach to deal with the issues? That's my question.
Yes, that's a very good question. Sometimes I forget to talk about the positive things as well. That's my nature. That's my heritage. I'm very sorry about that. So I still think it's great that we have that right to explanation. Like, even like the watered down version that we have right now is better than not having one at all. It's just really important that we see that there are limitations there and try to work as academics to give new interpretation, a new push, that this will be interpreted differently. The harmonized standards, this is where I think the big money is at the moment. Pushing in the direction, developing standards of what a good explanation looks like, that's the next battlefield. And if we can have voices in those decision-making bodies where criteria are going to be developed what a good explanation looks like, we can win this even if this is an imperfect version on paper. So I still think it's great, and I'm immensely grateful for the European Parliament to even putting those rights in there, because there were none conceived for the first couple of years. So really huge shout out to the Parliament on that regard, and holding the ground till the end, because it wasn't really clear that it will actually pass at all, and especially with those rights in there. So very sorry, there are positive things. I'm just saying those are like the to-do list of things we need to push forward to make those rights even stronger.
Hi, my name is Vaishak. I'm a master's student from Leiden. Maybe not completely relevant, but like today technology companies use dual-use technologies, like which is used for military purposes, because AI is being used for what you call as DSS, decision support systems, which what I understand is they also use large language models. So just wanted to know whether the same sort of processes involved in the assessment of the AI DSS systems, which are largely being used by states or defense contractors for, surveillance purposes.
I couldn't hear exactly well the question because here the audio is not. Can you summarize it?
So today, AI decision support systems are being used for military purposes, what you understand as dual-use technologies. And I know that military purpose decisions are not in the purview of the AI Act, but is there any sort of regulation that is there in just understanding how, especially tech companies develop, for instance, Microsoft or any other company, they could provide, systems for civil use, but even for military use, is there a different set of regulations that would apply?
I'm not an expert, but there is a dual-use framework which is currently in the process of being reviewed. But I'm not an expert, so I cannot tell you.
First, thanks to each and every one of you for participating in this, I think, very interesting panel. I hope some of you are now convinced that we might switch perspective. That was a question at the very beginning. And in any case, should you or not be convinced, I ask you to give a warm applause to our speakers who gave very interesting speeches.